Let's start with chapter 6 questions. Now, practical question one. Chalo. Mesa Zebra Private Limited was incorporated in the year 2016 under the Companies Act 2013 by three brothers, strong brother, namely A, B, and C. All three were promoter directors named in the Articles of Association and subscribed for 100 shares each in the company through MOA. Thereafter, from time to time, further shares were allotted in proportion of one third to each of them, and in due course, the company started coming substantial profits. Due to the greed of money, the two brothers, namely A and B, joined hands together and assumed complete control of the company, leaving the brothers C in lurch. Both the brothers got shares allotted to themselves, thereby their joint shareholding increased from 66% to 90%, while the shareholding of C got reduced from erstwhile 33% to 10%. No notice of any board meeting was sent to C, who was sidelined and was also removed as a director. Aggrieved by the decisions taken by his two brothers at his back, C seeks your advice for taking out appropriate proceedings before the court or judicial authority or competent jurisdiction. Also, suggests the nature of reliefs he may claim while filing his case. Operation means something wrong, burdensome, harsh, or unfair is done to any members of the company and which affects the members in his capacity. Chalo, operation means something wrong, burdensome, harsh or unfair is done to any members of the company and which affects the members in his capacity as members of the company. Issue of new shares to only group of shareholders and thereby diluting the shareholding of any existing member is a clear case of operation. Further, operation complained of must affect a person in his capacity as a member of the company. Harsh or unfair treatment in any other capacity, as an example, as a director, is outside the purview of Section 241. However, the company is in the nature of quasi-partnership or a small partnerships of a limited individuals, which although operating as a limited company runs as if they are partnership between those individuals at the control removal of a shareholder who is effectively a partner from direct, so that now the shareholder will have no money in the company also amounts to operation. In the given case, Mr. Zebra Private Limited has three promoters, namely ABC, allotment of new shares only to A and B and thereby diluting Mr. C shareholding to just 10% and then taking away his managerial powers by removing him from the directorship are grave acts of operation. Thus, Mr. C is advised to file a petition under Section 241 to the tribunal claiming relief from the oppressive acts of Mr. A and Mr. B. He can seek the following reliefs. The alleged allotment of shares should be declared as null and void. His removal null and void करना हो. His removal from directorship to be allotment null कर दो directorship null કરી નાખવાનો એ order એમ માંગી શકે કે મને આવો order જોઈએ છે પછી reconstitution of board of directors with the petitioner, his two brothers and an independent person to be appointed by the tribunal as a chairperson and the board of directors with a casting vote, making it mandatory to obtain tribunal's leave before removal of any director and or before issuing new shares in the company. ચાલો એટલે ચાર વસ્તુ એ કહી શકે કે મને આટલી આટલી પ્રોવાઈડ કરી દેજો શું છે પહેલું તો અલોટમેન્ટ ડિક્લેર નલ એન્ડ વોઇડ કરી નાખો પછી ડિરેક્ટરને જે રિમૂવ કર્યો તે બી નલ એન્ડ વોઇડ રીકન્સ્ટિટ્યુશન ઓફ બોર્ડ ઓફ ડિરેક્ટર્સ વિથ અ પેટિશનર અને મેકિંગ ઇટ મેન્ડેટરી ટુ ઓબ્ટેન ટ્રિબ્યુનલ્સ લીવ બિફોર રિમૂવલ ઓફ એની ડિરેક્ટર ચાર વસ્તુ એ માંગી શકે કે આ વસ્તુ આટલી એટલી કરી શકો ટ્રિબ્યુનલ પાસે કોઈ બી પાવર છે તમારે જે ઓર્ડર પાસ કરાવો હોય તે કરાવી શકો ચાલો પ્રેક્ટિકલ ક્વેશ્ચન 2. Mr. B. Dutt is a managing director of Food Plaza Restaurants Private Limited was incorporated in furtherance of a joint venture agreement between Mr. B. Dutt and Jack India Private Limited in 2021, both having 50% of equal share in the said company. FPRPL was to be governed by the terms and conditions set out in its Memorandum of Association and its Article of Association. GIPL held the board meeting without giving prior notice of such meeting to Mr. B. Dutt, took decision to remove Mr. B. Dutt with an allegation of mismanagement of funds in FPRPL. GIPL pressurized him to sell his shares at rupees 5 crores against rupees 15 crores, which was the fair market value of Mr. B. Dutt's Mr. B. Dutt's shares. Advice: operation means when something wrong burdensome. Okay, however, director complaints can be entertained in a petition. In the given case, Mr. B. Dutt was removed from the position of managing director without giving him prior notice of board of directors. Also, he was pressurized to sell his shares. Further, Mr. B. Dutt and Jag are in a joint venture agreement having 50% of equal share in Food Plaza. So it can be said that FPIPL is in the nature of quasi-partnership, hence removal of Mr. B. Dutt from the directorship and thereby absolving him completely of his powers in the shall amount to the operation. Thus, Mr. Bidat must make an application to the tribunal under Section 241 for claiming relief from the operation and deficiently. Tribunal shall pass necessary as it deems fit to the end to end the matters complained of. Practical question 3. State whether the aggrieved party would succeed in obtaining relief from the tribunal on the grounds of operation where the majority of the board of directors override the minority directors and the minority directors apply to the tribunal complaining operation by majority directors. Okay, પેલું minority and majority નું છે. The affairs of the have been are being conducted in a manner prejudicial to public interest, prejudicial to operative or any other, or prejudicial to the interest of the company. The material change has taken place in the management control of the entire reason such it is likely that the affairs of the company will be concluded in a manner prejudicial to its interest. As per the decision in the case of force where a company is managed as per the rule of majority, in the board meeting is director has one vote and generally a resolution is passed at a board meeting by simple majority. If the majority of directors have passed any resolution or has voted against a resolution, whatever the decision, it will be binding on all the directors. This does not mean that the majority of directors have oppressed the minority directors. Also, it was held in Rao versus Rajeshwari Ramanakrishnan that the operation complained of must affect a person in his capacity as a member of the company. Harsh or unfair treatment in any other capacity, example, a director or creditor is outside the scope of Section 241. Thus, in the given case, the minority directors cannot apply to the tribunal complaining operation by the majority directors. So, practical question 4. Mesa's City Hospital Private Limited has two groups of directors. A dispute arose between two groups, out of which one group controls the majority of shares. A very serious situation arose in the administration of the company's affairs when the minority group outstayed the lawful board of directors from the position and control of the management of the company's factory and workshop. Books of accounts and statutory records were held in the minority by the and consequently the annual accounts could not be prepared for 2 years. The majority group applied for the tribunal under Section 241 of the Companies Act to the viewer required. Can majority shareholders apply for relief against the operation? Okay. The material changes taking place in the majority can claim relief from operation if they are oppressed by the minority. Section 244 simply specifies the minimum number of members required to make a valid application. The section nowhere specifies the only minority members can have the right to claim relief from the operation and management. Thus, the majority shareholders can definitely apply to the tribunal for relief against the operation by the minority shareholders. It can be observed from the facts of the given case that the minority shareholders have clearly oppressed the majority shareholders. Thus, if the tribunal is of the opinion that the affairs of the company have been conducted in a manner oppressive to the members, the tribunal may pass such order as it thinks fit with a view to bringing to an end the matters complained of. Therefore, the tribunal is empowered to grant such relief as it may deem fit in the light of facts and circumstances of the case. Practical question 5. In application made to the tribunal claiming relief against operation and management, it is alleged that the directors of the company have misused their position in making certain intercorporate deposits which are against the interests of the company. Will the tribunal entertain containing such allegations? Okay, in the given case, the applicants have alleged that the intercorporate deposits made by the company are against the interests of the company. However, this is in itself does not amount to any operation or mismanagement. The applicants must satisfy the tribunal that the alleged action of the directors was done with a fraudulent intention and to prejudice the interests of the company. Only then the tribunal will entertain the petition. Merely because the decisions of the board of directors turned out to be incorrect, it cannot be said that there is a mismanagement in the company. But if those decisions were taken intentionally to defraud and prejudice the interests of the company, then it will amount to mismanagement. Thus, in the given case, the tribunal will not entertain an application merely containing an allegation that the intercorporate deposits are against the interests of the company. એટલે એવું નહીં થઈ શકે કે તમારા ઇન્ટરકોર્પોરેટ ડિપોઝિટ લીધો અને એનો ડિસિઝન તમારો ઊંધો પડી ગયો તો એવું નહીં કે એ ફ્રોડ જ છે. પહેલા એ ફ્રોડ પ્રૂવ કરવું પડે અને પછી તમે ફ્રોડ્યુલન્ટ ઇન્ટેન્શનથી તમે કરેલો છે તો જ પછી ટ્રિબ્યુનલ પાસ કરી શકે કે ભાઈ આ ખોટું કર્યું છે તો જ તમે ફાઇલ કરી શકો પછી. ચલો. Whether practical question 6. Whether continuation of directors in office after expiry of the tenure and where infighting continues among them amounts to mismanagement. In the case of Sishu Rajan, Datta and another versus Bholanath Paper House Limited, it was held that continuation of directors after the expiry of the tenure amounted to illegality as a result of complete deadlock in the board. There was just an equitable ground for winding up the company. Therefore, it amounted to mismanagement. એવું થઈ શકે કે કોઈ બી કંપનીને મિસમેનેજમેન્ટ કર્યું અને એનામાં એવું થઈ જાય કે વાઉન્ડ અપ થવાની સિચ્યુએશન આવી જાય તો પછી એ મિસમેનેજમેન્ટ કહેવાશે. Practical question 7. 60% shares of Indo-France Limited are held by French group and balanced by Indian group. As per article of the company, both the groups had equal managerial powers. The relationship between the two groups, SARD and the operations company, reached the deadlock. The Indian group approached the tribunal for action against the French group for operation. Based on this facts, you are required to decide with a reference to provisions and to decide the laws issue whether the contention of operation against the contention of that the foreign group is acting in a manner oppressive to India is not tenable. This is because both the groups have equal managerial powers. So there can be no oppression by one on another. Since there is a deadlock in management, it would amount to mismanagement as it is prejudicial to the interests of the company. The tribunal may order either of the groups to purchase the holding of the other group at a fair price. However, in case of inability of both the companies to buy the share of the other, the tribunal may order that it is just and equitable to wind up the company. જોઈ લેવાનું કે શું છે. Practical question 8. Mutual District Private Limited has two shareholders, namely A and B, holding 51% and 49% respectively. Both are working as directors. Due to differences between them, A decides to hold a board meeting on 30th April 2022, but the same could not be held due to the non-cooperation from B and lack of quorum. Advise Advise A about the steps that can be taken to resolve the matter. Where differences and they are not able to operate together, and as a result, there is a complete deadlock in management of this. In such a case, it can be fairly concluded that there is a mismanagement. In the given case, Mr. A and Mr. B are only directors of Mutual District Private Limited, and due to the differences among them, the board meeting could not be held. Thus, there is a deadlock in the management. Deadlock है in order to claim relief from mismanagement, Mr. A is advised to apply to the tribunal under Section 241, seeking relief from such a situation. The tribunal may on receipt of such an application, make any of the following orders. First, either A or B should be directed to buy the shareholding of other at a fair price or make an order of winding up or give such directions as the tribunal may deem fit. Next, practical question 9. Practical question 9. Three shareholders XYZ and company at X, Y, and Z intend to file a petition before the tribunal under Section 241 of the Companies Act 2013. To comply with the requirement of one-tenth of the shareholding, the shareholder X gave consent in writing for and behalf of his daughter, also shareholder, who has authorized her father to act on her behalf. General power of attorney is the consent given by yes, the consent given by a shareholder being a general power attorney on behalf of his daughter is a valid consent. Practical question 10. A group of shareholders consisting of of 30 members decide to file a petition before the tribunal for relief against operations by the member of Mrs. Aravali Manufacturing Company Limited having a paid up share capital of rupees 1 crore. The company has total of 500 members and the group of 30 members holds one-tenth of the total paid share accounting for 1/15th of the issued 1/15th of the issued share capital नहीं आवश्यक 1/10 of the आवश्यक. The grievance of the group is that due to the mismanagement by the board of directors, the company is incurring losses and has not declared any dividend for the past 5 years in the right. Okay, 100 members of the company or one-tenth of the total members or members holding not less than one-tenth of the issued share capital of the members. However, has the deduction to allow even lesser number of to make an apply in the 500 only 30 members have applied who hold 1/15th of the issued share capital. We can see that the criteria of applicant by at least 100 members is not fulfilled. The other criteria of application by at least one-tenth or that is 50 is also not met as only 30 members have made application and finally the application can be made by members holding at least one-tenth of the issued share capital of the company is also not achieved as the members making application hold only 1/15th of the issued share capital. Thus, the criteria of application under Section 241 by requisite number of members specified in Section 244 is not fulfilled. Also, the shareholders may not succeed in getting any relief from the tribunal and continuous losses cannot as continuous losses cannot by itself be regarded as operational mismanagement and merely because no dividend is recommended by the directors of the company also does not amount to operation or mismanagement. Dividend નથી આપતા તો એવું નથી કે operation mismanagement કરે like just an equitable grounds તો લાવો prejudicial to interest of the company કઈ તો એવું જોઈએ members કે એવું કઈ આ તો તમે કઈ બી લાવીને મૂકી દો ચાલો practical question 11 practical question 11 chart. The issued and subscribed and paid up capital of ABC Limited is rupees 10 lakhs, consisting of rupees 90,000 equity shares of rupees 10 each fully paid up, 10,000 preference shares of rupees 10 each fully paid up, out of out of members of the company, 400 members holding one preference share each and 50 members holding 500 equity shares applied for relief under section. As on the date, the company had 600 equity shareholders and preference shareholders and 5,000 preference shareholders. Examine whether 100 members of the company or one tenth of the or however the tribunal has a discretion only. Applying the above provisions, 100 members of the application must be made by the lowest of the following: 100 members of the company or 1/10 of 5600, that is equity plus preference shareholders. So 560 members or members holding 1 lakh being 1/10 of issued share capital. Issued share capital કેટલું છે? The issued offer is rupees 10 lakhs. Okay, issued, subscribed and paid up 10 lakhs. અચ્છા ચા વાંધો નહીં. તો 10 lakhs એટલે 1/10 એટલે 1 lakh નું thus the application must be done by at least 100 members. Since the given case the application is done by 450 members, that is more than 100 members, the application is valid as per section 244. Further, as per in the case of okay, the Rajamundry Electric Corporation versus V. Nageshwar Rao, the consent of the application must be obtained prior to filing application and is recorded at the beginning of the proceedings. If some of the members withdraw their consent during the course, it shall not be amounting to okay. Examine whether the above petition is pendable, which will be different if preferential was subsequently withdraw there. Okay. Subsequently withdraw करे तो कोई फर्क नहीं पड़ेगा अपाई हुई लो अपाई हुई does even if the preferential holder subsequently withdraw their consent the answer will still remain the same and the application would still be maintainable એવું નહીં કે તમે એક વાર કરીને ભાઈ ભાગી ગયા તો બી મેન્ટેનેબલ તો રહે એવું નથી કે ચાલ્યું જાય ચાલ practical question 12 MNC Private Limited is a company in which there are six shareholders Mr. Srinath, who is a director and also the legal representative of a DC shareholder holding less than 1/10 of the share capital of the company, made a petition to the tribunal for relief against holding less than 1/10 of the share capital. Okay, six shareholders. Okay, કરી શકે ને 1/10 all 100 members of the company or 1/10 also further even the thus as per the provision legally is entitled to make an appeal under section 241 further there are only six shareholders so 1/10 of the number is 0.6 which means even a single number can make an application to the tribunal in the given case regardless of the fact that it holds less than thus Mr. is valid and maintainable 1/10 follow જોઈએ પતી ગયું છે practical question 13 Masons DJ Limited, the listed company, as per the audited financial statements of March 31 to 22, is having issued and paid up capital of rupees 10 lakh. Issued paid up capital 10 lakhs of rupees 10 each, and issued paid up preferential capital of rupees 5 lakhs of rupees 10 each, respectively. Okay, 5 lakh and 15 lakh થઈ ગયું. The members of the company, after complying with the provisions of Section 169, removed one Mr. Satish from the directorship of the company on 1st August before the completion of his term of office. Mr. Satish is also one of the members of the company holding 1 lakh 1,10,000 fully paid equity shares. Mr. Srinath has alleged operation on his removal and is okay. The board of directors also stated if any other recourse that is available under the provisions. In the given case, the application is made by one member holding more holding share capital 11 lakh. However, the issued share capital of the company is rupees 1.5 crores. Therefore, Mr. Satish, who is holding less than 1/10 of the issued share capital of the company, thus the application made by me is not maintainable as per okay for the bona fide exercise of powers given by the does not amount to operation. The only recourse is with Mr. is to make an application to the tribunal for the waiver of the requirement of requisite majority as given under section 244 to be eligible under to apply under section 241 કે ટ્રિબ્યુનલને કહી દે કે હવે આ હટાડો તો પછી થઈ શકે નહીં તો નહીં કરી શકે Practical question 14. Arctic Refill has got 5,000 shareholders. Some of the members have decided to file an application in the section 241 of the for operation. Discuss the qualification of members due to fresh issue of the shareholding of the share members who file the petition gets reduced to below the required percent of the old of the old paid up share capital. The main contention in the petition is challenging the validity of the petition under Mr. Dina. One of them also wants to file an application for operation. Can he do so? Whether either one or more holds at least 1/10 of issued share capital of the company or 100 members apply to the tribunal. It must be noted that in case the shareholding of the petitioner member gets reduced to below 10% of the issued share capital because of fresh issue, which is challenging as oppressive, the maintainability of the petition would be reduced after determining the validity of the issue of allotment. The petition shall be maintainable and the petitioner member shall be entitled to relief. As per the judgment in Rao versus Rajeshwar Ramakrishna, it was held that the operation complained of must affect a person in his capacity as a member of the company harsh or unfair treatment in any other capacity. Example, a director or director is outside the scope of this section. Thus, Mr. Dina, one of the directors of Arctic, cannot file an application for operation. One of the directors. Okay, as per the judgment, it was held that the operation complaint of must affect a person in his capacity as a member of the company. Okay, member of the company માં હોય ને તો જ એ વસ્તુ લાગી શકે નહીં તો નહીં લાગી શકે. Cannot file an application for operation and management. Okay. Practical question 15. A group of shareholders holding 20% of the issued paid-up share capital of DEF Limited filed a petition before the tribunal alleging the following: various acts of illegal, invalid, and irregular transactions entered into in the name of the company, losses incurred due to the mismanagement by the board of directors, non-declaration of dividend, various acts of losses incurred due to mismanagement by the examined the merits of the company. It was held. Okay. Okay. As well, in the case of in the given case, since a group of shareholders hold 20% of the issued share capital, they are eligible to file a petition to the affairs of the company. It was held in the case of Sheikh Mohanlal Ganpatram versus Sri Sayaji Jubilee Cotton and Jute Mills Company Limited that mere illegal, invalid, and irregular transaction entered into in the company of the company do not consider as valid ground for claiming relief under Section 241 unless it is proved that they are prejudicial to the interest of the company or public interest or oppressive to the any member એવું નહીં કે તમે ભાઈ ખાલી રેગ્યુલર ને એક્ટ કર્યો એટલે તમે પ્રિવેન્શન ઓપરેશન નો પણ એવું નહીં પણ તમારે જોવું પડે પબ્લિક ઇન્ટરેસ્ટ વાળું. As per the decision, Ashok Betanat Consumer versus MK Chandrakant condemned due to mismanagement cannot be itself regarded as operation. Also, merely because no dividend or low dividend is recommended by the directors does not amount to operation. Thus, in the given case, the petition will fail unless they can prove to the satisfaction of tribunal that the acts complained are operational to them in the capacity of members or are prejudicial to the interest of the company or public interest. Practical question 16. 15 members of Kun Limited holding 15% paid up share capital who have paid all the calls and other sums on of the company under Section 241 for relief from operation. The tribunal admitted the application and upon inquiry found the allegation to be genuine. Thereupon, the tribunal on 1st October ordered for termination of Mr. Bab, the managing director of the company with immediate effect. Mr. Bab was appointed as a managing director for a period of 5 years with effect from 1st April, having a clause in his letter that he would be entitled for compensation for the remaining period in case his services are terminated by the company before expiry of his stipulated time. Mr. Bab claimed compensation for the remaining term of 1.5 years. Couldn't deny to pay the compensation, but offered him to reassume his office again after a lapse of a period of 3 years from 1st October 2020, referring to analyzing the relevant provisions. Kun Limited is valid. Okay. As well, the tribunal may, with a view to bringing to an end to the matter, complaint of under Section 241 makes such order which makes provides for inter alia the termination, setting aside, or modification of any agreement, however arrived at between company and managing director, any other director or manager upon such terms. For the as per Section 240, where any such agreement is terminated, it shall lead to the following consequences. Such or shall vacate his office. Such managing director shall not be entitled to claim any damage or compensation for loss in office. Such director or manager shall not be appointed as a managing director, director or manager of the company for a period of 5 years from the date of the order terminating or setting aside the agreement without the leave of the tribunal. The tribunal may applying the above Mr. Bab's claim for compensation for loss of is not tenable. Proposal of Spoon Limited to offer resumption Mr. Bab after 3 years termination of his office is also not valid because as per Section 243, Mr. Bab cannot be appointed as a managerial person in the company for a period of 5 years. However, if the tribunal, after consultation with CG, grants leave to Mr. Bab, he can be appointed in the company before the expiry of the said 5 years. CG जो grant करेगा वो अच्छी चाल Sure. Practical question 17. Mrs. Sunshine Oils Limited, a listed company as on 31st March 2022, as per the audited financial statement, is having 200 depositors with rupees 50 crores of deposit in the company. Out of the total 200 depositors, 20 depositors having formed a group and have appointed Mr. Rama practicing, who is not one of the depositors as a report to find the NCLT, to bring a class action suit against the company as they are of the opinion that the management and have conducted affairs with the application of Ram. The requisite number of depositors who are eligible 100 depositors or 5% of the total number of depositors or one or more depositors or for whom host 5% of total deposits of the company. Applying above to the given the application is made by 20 depositors out of the total 200 depositors 28 okay 20 1/10 આવી ગયું ને that the management and conduct of affairs of the company are being conducted in a manner which is special to so the application is made by 10% of the total number of depositors 20 divided by 200 into 100 which is more than prescribed 5% of the total number of deposits. Also, Section 245 does not require that the person authorized by the depositors to file a class action suit before the tribunal must be one of the depositors. Rather, as per Section 432, a party to any proceeding or appeal before the tribunal may appear in person or authorize any one or more chartered accountants, cost accountants, companies, legal practitioners, or any other person. Hence, such class application is valid, and the authorization given by the depositors to Mr. Ram to present a petition on their behalf is also valid. એ ચાલે કે તમે કોઈને બી આપી શકો કન્ડિશન શું છે 100 depositors હોવા જોઈએ ત્રણ કન્ડિશન છે 100 depositors કાં તો 5% of total number of depositors 5% of total number or one or more depositors whom 5% of total deposits of the company એ પોતાના નામ પર હોય. તો આમાં condition કઈ પૂરી થાય છે? સેકન્ડ વાળી 5% of the total number આપણે 10% લોકો કરીએ તો conditions પૂરી થઈ જાય છે. થેન્ક યુ.